Most humbly and respectfully, may it please this honorable. I appear before this High Court of Maharashtra on behalf of the applicant, Open Analytics Private Limited, in their appeal against the order of the Data Protection Board of India. Hereinafter referred to as the DPL. The jurisdiction of this honorable court is involved under the active jurisdiction under the Articles 226 and 227 of the Indian Constitution against the order passed by the DPL. We invoke this writ jurisdiction because under Section 29 of the Digital Personal Data Protection Act of 2023, which is the DPDPA Act, it is said that the applicants may appeal to a higher tribunal. Now, if we read that section, we construe that the applicants are not necessarily required to approach the bench.
Also, I would like to interrupt you at the very outset because first I want to understand, can you just in 2 lines tell us what your case is about? Just 2 lines.
If it pleases the court, the applicant, Open Analytics Private Limited, is a leading technology firm specializing in an artificial intelligence. In early 2024, the applicant entered into a public-private partnership with the Ministry of the Public Order or the MOOT Europe, which is mandated by the Union of India. The objective of this partnership was the development and deployment of the AI project, Sense, which is an AI-driven surveillance engine designed to enhance public security, detect criminal activity, and manage public order in real time.
No, Ms. Mlsu. I'll interrupt you. We are clear with the facts because we have read our brief, we have read the case files, we have read the report. I just want in 2 lines what is the case about? Like, what is the core issue there? What is the constitutional interpretational aspect which requires a 3-minute bench? Just give me just what your case is about.
Obliged, my lord. I should proceed on to explain why the applicants are being implicated in this case as the data fiduciary when in fact they are the data processor and being held under the GDP Act and an astounding rupees 180 crores of penalties being imposed on them without any reasoning and their trade rights under Article 91G of the Indian Constitution are being violated, which is why the applicants most humbly reach this bench.
Okay. Proceed with the first issue.
Sorry to interrupt. I just want to understand this also. See, you have this by way of review.
By way of jurisdiction.
So you are under 246 or 247?
That is correct.
246 or 247?
226.
Not 247.
And technically 227.
Okay. And secondly, see, you have I want to understand Union of India and others. Who are these others? I need to understand. You have filed this petition made by Open Private Limited versus Union of India and others. Who are these others parties?
The other parties are the Data Protection Board of India, which is the authority, the tribunal which passed the order against the applicant, and the Digital Rights Forum, which is the DRF.
Okay, proceed.
I shall humbly divide my submissions into 3 contentions. First, that the applicant has been wrongfully classified as data fiduciary and instead qualified as a data processor under Section 2, Subclause A of the DPDP Act. Second, that the collection and processing of data was lawful, specific, and compliant with the safeguards of Sections 4 through 9 of the Act. Third, that the
Sorry to interrupt, Ms. Counsel, I just want to ask one question. There is a provision of appeal also. Why did you choose, why would you have Honorable High Court? You would have gone to release it and telecom dispute every federal tribunal. There is this provision if you are heavy by the order of the board. You should have gone there.
You are correct to point that out, my lord. But Section 29 of the DPDP Act says that the applicant may approach the applicant tribunal.
That's why we are telling you that why have you not invoked your first right to go before the authority.
We have invoked the jurisdiction because the fundamental rights of the applicants are being violated in this present case, which is Article 19, 1G of the Indian Constitution. Therefore, we are approaching this bench under the jurisdiction.
Don't you think 91G comes with reasonable restrictions?
That is correct, my lord. I will deal with those arguments later in my
I
discussion.
want you to deal them first. Come to your issue.
Uh, should I continue with my
Please,
first
yes,
submission?
we are waiting.
Right. My lordships and my ladies, the DPP committed a manifest error by classifying the applicant as a data fiduciary. We submit that cornerstone of the DPP Act is differentiating between what is a data fiduciary and who exactly the data processor, which under Section 2, subclause I, is an entity that determines the purpose and use of processing. In the present case, the Ministry of Public Order, which is the MOOT, mandated that in order to enhance the public security and law enforcement through the Renaissance Project, the applicant did not just wake up one day and decide to survey the citizens of India. We were invited by the state under the public-private partnership to execute a predefined state objective. Coming on to the means test, just because the applicant developed the AI project or the algorithm does not mean we define the means. We submit that this is a technical fallacy. Developing the technical tools is not the same as determining the legal means. The MOOT provided the surveillance infrastructure, the access to the feeds, and the legal authority to process. The applicant was merely the engine room, a class of data processor under Section 2, subclause E of the DPP Act. Since the ministry controlled the data source, which is hours of CCTV footage, the legal compliance was vested with the respondents and not the applicants. In the Indian jurisprudence, the court in the cases of Ajay Hasla and Sukhdev Singh, which if the bench could please turn to tabs 2 and 36 of the case compared for the applicant.
Mr. Counsel, before we come to any pronouncement, let's have a little focus on the fundamentals of the issue. You say you are not a fiduciary.
That's correct.
In my understanding, and I'm speaking on behalf of the rest of us, is that the moment you process a data, you give a certain algorithm to the process, you give certain quantification in terms of how this data will be processed, and it is all based on mathematics, because computers works on 0 and 1. So when this data is collected, when this data is processed, you create a certain pattern of mapping in which an individuals are identified as a potential threat. They are on the basis of their age, gender, color, height, weight, dressing pattern, and the moment it is based upon these exponentially objective criteria, there has to have a bias. Because the moment I say a black man 7 foot high in a large build, it's a red flag that he can be a potential danger to the public. How come it is not violated Article 21, where a right of equity is attached to it? Because before I am being convicted for anybody, you have already classified me as a potential threat. So before you argue on your 1912, I want you to first establish how Article 21 of these individuals is not violated. So now explain to me that if you create a bias towards the scene, how come you are not a fiduciary?
I'm grateful that you raised this concern, my lord. Article 21 is not being violated here because the applicant was mandated to process the data on behalf of the Ministry of Public Order. Now, the Ministry of Public Order's job, let's say in this case, was to identify certain individuals who were potential threats to the society. The ministry mandated the applicant to conduct such surveillance and to analyze certain characteristics which would behaviorally lead to analysis of people. This is something that was mandated by the ministry, and it was not something that the applicant was responsible for. The applicant is merely an AI processor. They would give the characterization of people, and the ministry themselves or the executives were responsible for avoiding an automated decision-making process and apply their own human mind to such automated answers by the AI in order to segregate between who is a potential threat to the society and who is what. The AI processing is merely a function, merely a stepping stone towards a final decision. So the applicant here is not really the fiduciary. They are just being implicated in this case as a fiduciary, even though they are just processors on behalf of the ministry.
So you don't retain any data of these individuals which you collect by CCTV footage? You don't retain it?
My lords, once the data has been processed, it is being forwarded to the ministry in order to execute certain functions. The data is being retained so that the individuals who are being processed under it are still under surveillance in case they are marked as a pension aggregator in a society that can be disrupted because of their actions. That is why the retention of the data is necessary in this case.
But you have also employed the data in the YouTube and social network. You can't say that you have only given the data to the ministry. You should have the authority to employ the data on the YouTube channel, social networking. Because the agreement was very specific that some hours of the data will be given to you, and then you will be using that 9 cents and you will be doing your part. Right? But that was not the part of the agreement that you will upload the data on the YouTube. So you have actually violated these people's right. What do you say on that?
If it pleases the bench, I would like you to refer to the factual basis of the case. The applicants did not surveil the online data, they merely used it for their own training purposes, training of the AI purposes. It was not forwarded to the ministry for the purposes of surveillance. That was for the AI training so that AI accuracy would be increased. So that is something that is not under violation under the agreement.
This AI training column is the subject of your agreement or not?
The AI training.
Have you taken permission for it? That you are using this data for your AI training purpose? Is this not the violation of the agreement?
My lordship, this is an extension of the agreement, if anything, because the ministry.
Is there any extension in return?
There is no extension in written, but there is implied
You
extension.
are talking contradictory, madam. You are talking contradictory. You are just saying there is an extension of the agreement, and you say that there is no extension written.
My ladyship, I would like to correct myself. My apologies. It is an extension of the agreement because by way of the agreement, we were mandated to process data in order to mark potential aggregators. Now, it is an extension because in order to do such an act of marking people in a certain manner so that it leads to better public order, AI training is required. And that is something that is implied in the agreement that we will have to train our AI in order to better recognize the potential threats. If it pleases the bench, then please move on to my issues. Much obliged. Now I will come on to the principal agent doctrine for the matter of the relation between the applicant and the Ministry of Public Order. In Indian jurisprudence, the courts in Ajay Hasia and the Supreme State cases, if the lords could please refer to tabs 2 and 36 of the case compendium of the applicant. It was held tabs 2 and 36. The lords is reading. The court said that when a private entity performs a function at the behest of the state and under the control of the state, it acts as an instrumentality of the state. A data processor is by definition an agent and to hold the agent liable for the policy decisions of the principal, which is the ministry in this case, would not be right. The state herein is the MOOT, since they are the extension of all the functions, fundamental or financial, that are required for the public order. And by way of the contractual agreement, this extension would apply to the applicants.
So you are saying you fall within the definition of instrumentality of state.
That's correct.
So being an instrumentality of state, you are bound by the constitution of your country.
That's correct.
Precisely. So that means that there are certain fundamental rights of every citizen. And you have to strike a balance in terms of Article 14, 19 and 21. Because you started with your argument that your 19 G is being violated. Let's talk about 14 and 21 first. Because they are absolute. They don't come with any legal restriction. If I step out of my house and I know that my every movement is being watched all the time, even if I have not committed any crime, I am under a constant surveillance. that my data is being processed by a machine, which is a private entity, on behalf of the government, and my every movement is being mapped, and my future life depends upon how this AI is mapping. So if I'm going out in a group of people, I'm identified as a potential threat. If I go for a walk in the evening, I'm identified as a potential threat. If I have a cuff and I'm wearing a mask, I'm identified as a potential threat. How this is not violated to my right to live as a dignity where I know that I am under constant surveillance all the time?
Thank you for raising this concern, my lord. I would like you to refer to tab 19, paragraph 638 of the case with the Swami versus Union of India case. So that particular case says that right to life is not an absolute right and it is subject to certain constitutional restrictions. Paragraph 68 lays down these certain restrictions, which are as follows. The action must be sanctioned by law. The proposed action must be necessary in a democratic society for a legitimate aim. The extent of such interference must be proportionate to the need for such interference, as well as there must be procedural guarantees against abuse of such interference. All of these boxes are checked by the applicant. We were mandated by the state in order to process the data that is publicly available to us. The CCTV footages were supplied to us by the Ministry of Public Order in order to assess what the citizens of the country were doing, and under the mandate duty we were supposed to categorize them as someone who possesses a risk to the society and someone who does not. Moreover, we are a private body, not a state instrumentality. We are state instrumentality by way of the agreement, because the Ministry of Public Order is the state instrumentality who mandated us to execute certain actions and train our AI. So, my lords, we are not violating Articles 14 and 21.
No, you only address 21 that it comes with the, because you read the Swami judgment here. Okay, let's come to another article 19(1)(a), my freedom of expression and speech. Now, I know I am constantly being surveillance. Now, I have a right to participate in an agitation. I have a right to give my opinion in a democratic country. But the moment I raise my voice, I know that somebody is watching me and they will put me under a certain bracket. Maybe because I is a concern. So I am always suppressed by a self-regulation not to speak, because this AI which is watching me is going to put me as a potential threat. Why is it not suppressive to Article 19(1)(a), wherein I don't have freedom of speech now? Because I am always under a threat that somebody is watching me.
My lords, I would say that is an incorrect interpretation of the processing of the AI, because we are very processors. The executive, which is supposed to dictate people based on these actions, are supposed to apply their human oversight over the conclusions of the AI. AI itself won't lead to automatic detention of certain people because of certain actions that they do. So the AI is being trained for this very purpose. Then it can detect what actions can lead to such riots or worse public order. Moreover, Article 19(1)(b) provides reasonable restrictions over such actions on freedom of speech and expression. In the case of Anuradha Hassan as well, the courts were kind enough to lay down four-part proportionality test, wherein legitimate aim, legal necessity, proportionality, and legality of the such actions would be determined by the processing authorities. Here, the applicant checks all of these boxes.
Okay, but you are not satisfied there. But
I shall address your concerns in my subsequent issues. If it pleases the bench, shall I move on to issue 2?
yes, please.
Assuming arguendo, though not conceding, that the act applies to our actions. I move on to my second contention that the processing of CCTV footage was entirely lawful under Section 429. The Data Protection Board of Indian has penalized the applicant for failing to provide notice under Section 5. and seeking consent under Section 6. However, Section 7, subclause B, specifically states that personal data may be processed for any function under any law or for the performance of any function of the state. Now, I would like my Lord and my lady to bring their attention to 1.5 clause of the Bible for the act. Clause 1.5 states, mentions specifically that government of India has been transformative and strategizing national security by strengthening its defense systems, which includes funding development agencies for specific technology. This has been officially released by the government of India under their press release as per citation 5 under the clause. For the development and betterment of AI training, this consent requirement and this notice requirement has been waived off as per Section 7 subclause B, because it is a duty for the performance towards the state's functions and a mandate by the ministry itself for better surveillance. My lords and my ladies, public security is a non-delegated function of the state, and it has been time and again held in certain cases, such as A.K. Roy versus Union, that certain functions are non-delegated because they're core functions of the state and they cannot be delegated to further administrative bodies. When the Ministry of Public Order uses AI to detect threats, it is performing a statutory duty. Section 7 acts as a non-obstant clause to the requirements of Section 5 and
Yeah, I'll interrupt you again. When you talk about this duty, duty comes with responsibility and that. Great power comes great responsibility. The old saying. Tell me, what do you mean by consent? Do you take consent of people when you collect their data? So, if I post my selfie on Instagram where I'm having my lunch today, whom I'm hanging out with, which place I'm going to, all these information which is available on public platform, which I have consented to post, I never consented you to use it to create a profile of pattern of my lifestyle. How do you justify that I have given you consent?
My lord, whenever a person posts something on a social media segment, let's say a picture of themselves or a photo of themselves, they are bound by the terms and conditions of that particular website. The terms and conditions is something that the applicant would not like to delve into because their moral and ethical character is something that needs to be assessed separately in time.
So, based on what I'm posting online, you are judging my morality.
That is incorrect, my lord. We humbly submit that based on whatever you post online, that is only for the purposes of AI trading. That is not something that is being marked
No,
or
you cannot. No. I completely differ and disagree with you. Is that whatever I'm posting, I have not given you consent to use that data which I have posted. It is voluntarily sufficient for the people I want them to see, be it general public. But I never consented that you exploit my personal data for your 1920. I never consented this data to be exploited by you so that it violates my right of privacy, even if you're talking about the bigger picture of potential threat being assessed and being marked. How do you define consent when the public has given you consent to use this data?
if it pleases the bench, then please refer to a colloquial example.
I would love to hear that.
Sorry.
I would love to hear that.
So let's say you're using Instagram alone. You post a video. You also have the option to make your profile public or private in this case, which under the terms and conditions of Instagram specifically would mean that public profile is accessible to anybody around the globe. But a private profile will only be accessible to certain number of individuals who you allow to see your profile.
Okay, go on.
So in this case, this private profile and public profile acts as a gate between the applicant and the respondent.
But you have not just used Instagram. The proposition is clear. You also use YouTube. Then in YouTube, there is no public or private profile. A video once posted on YouTube is going to be there for eternity.
This was just
So even if I today, at the age of 44, once I complete 64, My 44-year-old version will always be there for you to use it the way you want it. Where is the consent?
My lords, the terms and conditions of Instagram were settled from the one factor of YouTube. YouTube has its own sets of terms and conditions which you did comply with. And what if those terms and conditions said that your data can be processed or used by anyone and we consent to it? So that is entirely dependent on the terms and conditions of the particular social media setting that are posting your video or photo to. My lords, I would like you to refer to case Micro Labs versus LinkedIn under tab 16 of the case complaint. This clearly states that laws are not violated when they are without authorization provisions only apply to computer systems where access is restricted by a gate, the gate that I was talking about earlier. This gate may or may not exist depending upon the terms and conditions of that particular site. If it pleases the bench,
Also, just tell me, so consent is required to upload data on YouTube or not? Consent is required or not required? When you're uploading data on the YouTube, so consent was supposed to be taken or wasn't required to be taken?
if the terms and conditions of the website allow the data to be extracted, why not?
So what is the case? Is it allowed or not allowed?
It is allowed. If it pleases the bench, I would like to conclude my submission of
Please.
In summation, my lords of the lady. First, the applicant is a processor, not a fiduciary. Second, the processing was a legitimate state action under Section 7. And third, the data was used either public or exempt under Section 17 for law enforcement purposes. The DPPI's order is a result of hyper-technical reading that ignores the ground reality of public-private partnership and clear statutory exemptions provided by the Parliament. Unless the honorable bench has further questions, I would humbly request to conclude my submissions and leave to my co-counsel.
Please.
My short. You may also approach.
See, that's consent.
May the council refer to the bench as your lordships in your leadership. Your lordships, your leadership, I will be addressing the issue regarding the constitutional balance between Article 19(1)(g) and Article 21 and the alleged action of the applicant that has been subjected to a disproportionate penalty under the Data Protection Act. The applicant, your lordships, your leadership, respectfully submits that the prohibition imposed on the applicant's AI research strikes at the very heart of its constitutional freedom under Article 19(1)(g). The development of the applicant's AI system constitutes legitimate technological research and commercial innovation squarely falling within the freedom to practice any profession. I would request your lordships and your leadership to please turn to page 37 of the applicant's memorial in order. Your lordships and leadership, Article 19(1)(g) is subject to Article 19(6), which is reasonable restrictions. Now, a case Mohammed Farooq, the judgment had applied a test to assess this reasonability. And this was also reiterated in the crypto judgment, which is the Internet Mobile Association judgment. In order now, the council would apply this test to the current facts at hand. The test goes, as I will read from the memo itself. Firstly, the restriction should have a direct and immediate impact upon the fundamental rights of the citizens. Secondly, the large public interest sought to be ensured in the light of the object to be achieved. Thirdly, the necessity to restrict the citizens' freedom, the inherent pernicious nature of the act prohibited, and lastly, the possibility of achieving a less restrictive measure. Applying it in a conjoined manner into the facts, firstly, the restriction has a direct and immediate impact on the applicant's Article 91G as it has effectively halted the applicant's AI research and commercial operations.
If you talk about professionality, then just tell me one line. What are you trying to achieve there?
Your Lordship, so what I'm trying to achieve here is that there was an absolute ban on my AI research by the DPPI's order, and there should have been a less inclusion and less restrictive measure.
No, that's because the question is by this AI, this model which you have created, wherein you are using the public data, what are you trying to achieve?
We are trying to we're trying to achieve public order. We're trying to assess if there are any crowd management or like potential agitators that are there. So, in order to facilitate what the intention of the government also was through the contractual agreement, we are trying to assess what is best for public safety.
You know, I'll give you an instance. If you remember 2611 attack, right? Outside Taj Hotel, the media was giving a live update, and the mastermind sitting somewhere were guiding the terrorists that now the cops have reached, now the SOT has reached, now do this, do that. This AI model which you are creating is just numbers. Anybody can use it in their advantage. So what the name of you are saying that you are trying to achieve a public order. Somebody sitting can also guide that where the police is going to be, so don't go from there, go somewhere else. How are you going to ensure that this is going to be productive and not counterproductive? Because it's all numbers, it's all 0 and 1, it's all profiling. So if you can profile citizens, why a terrorist cannot profile the movement cops? How are you trying to strike that balance?
Yes, Your Lordship, I completely agree, and I do understand your concern with this and the larger concern as well. But Your Lordship, we are just saying, first of all, we are merely a startup. Second of all, when the Data Protection Board is giving an order, which will be my issue 5 regarding the proportionality of the penalty, which we also oppose, if the knee-jerk reaction of a prohibition is what we are against, and since we are a startup, since there are other regulatory compliances that could have been imposed on us, that was not the first thought of the board while giving this order.
So you want us to be lenient just because you are in a startup? You owe less responsibility just because.
No, Your Lordship, the only thing is that the board has not reasoned themselves enough to tell us as to why they are imposing this in the first place, and the order was not reasoned to say that. Okay, so moving on to my next issue, the section 33 deals with the penalty clause. In order to impose that penalty, also the board has to give reasons as to why they are imposing that
No,
penalty.
we are actually thinking to increase the amount.
Your Lordship, I don't think the amount should be. It's already
Then you satisfy us on the grounds of this balance between 1913, 21 and 14. If you can satisfy this code that the restrictions are not reasonable, you are just creating a platform for larger public good, then we might think. Otherwise, we are actually in an agreement to raise the penalty.
Okay, Your Lordship, so Rachel, let me just apply this test for you, and if the bench is satisfied, then I shall move further and develop a creative argument. So secondly, the larger public interest which is sought to be achieved, the protection of privacy is definitely a larger public interest, but the measure adopted in order to stop our business is disproportionate to the object which is sought to be achieved. We are merely applying the constitutional test, and which is why we think that it was a disproportionate response. Thirdly, Your Lordship, the necessity to restrict the citizens' freedom. As I said, there could have been a regulatory compliance mechanism and to address the concerns. AI is a growing field, technology is needed, we need to develop in this field, and for that we need to train and research as well. Which is why if you prohibit our business completely, we are devoid of that right and we are devoid of correcting whatever, if ever it went wrong as per the alleged actions. Fourthly, Your Lordships, talking about the applicant's activity does not possess any inherent nature or pernicious nature because there has not been any concrete tendency that it harms, concrete evidence or tendency to show that it harms the general public. They were mere complaints and no official investigation prosecution was done against them to ensure that any future harms would have occurred or that they had already occurred. Lastly, Your Lordships, which is very important, possibility of achieving a less alternative or restrictive measure. And for that, we would suggest that there could have been conditional licensing, there could have been multiple other options. But the or imposition of the hefty penalty as well as the ban should not be the first punishment by the board itself. So the applicant also respectfully submits that the innovation and emerging technologies cannot be stifled based on these speculated apprehensions. Uh, Thus, the restriction is excessive, disproportionate, and should be constitutionally impermissible. With your Lordships and Ladyship's permission, we will move to the next issue pertaining to the penalty aspect. It is humbly submitted that while right to privacy is undeniably protected under Article 21, it is clear that the applicant cannot be made the constitutional scapegoat for such systemic surveillance concerns. The penalty is ultra-wide section 33 of the TTT Act. As per section 33, subclause 2, which uses the words shall have regard to specific statutory factors, if I may read, the first one is the nature, gravity, and duration of the breach under section 33 2A. Assuming arguendo, nature and gravity are established. Arguendo. The aspect of duration has not been explored by the court. There is also a subclause of repetitive breach. There is no repetitive breach by the applicant that has been reasoned by the court. There is no duration aspect that has been reasoned by the court. It's a startup, it's a pilot project, and it happened once only if it did happen at all, the deployment aspect. Now, in order to impose a hefty penalty of 180 crores, you need to satisfy all of these subclauses which are not being satisfied as per the Data Protection Board unreasoned order. Hence, since it's an and provision and none of this is being satisfied, it's not being told anywhere either 180 crore penalty is imposed. It's the penalty does pose ultra wide section 33 of the Data Protection Act. Moreover, using a few proportionality principles from certain settled case law principles, such as the modern dental college case, which talks about how there should be a legitimate aim, rational nexus, necessity, and a balancing interest. Over here, there is no demonstrated measurable harm as such. There is no data principle that has been identified as having suffered any injury. No unlawful commercial exploitation is established, and the system was deployed in a pilot stage. Moving ahead, Your Lordship. Another case for Hindustan Steel Limited, the Supreme Court has also stated that the penalty should not be imposed ordinarily for any technical or general breaches. Over here, the court has failed to consider that this was a public-private partnership context. The governmental oversight was also there in the deployment. There was an absence of any unlawful gain from this, and there were public security objectives as well, which we have cited out from Proteswami, like my co-counsel had done. Thus, there was a violation of Article 19(1)(g) because the reasonability test was not satisfied, and the prohibition and an absolute ban could have been avoided by giving a regulatory or a compliance-based measure. If your Lordships and Ladyship are satisfied, may I move to the threads?
No. I have one last question to you before you come to the prayer. First, tell me, are you just a machine? Is it just a machine? I'm asking you.
Yes.
For each.
It is.
It is just a machine. So there is no human intervention when you collect the data, when you process the data, when you profile it, when you segregate potential threats. There is no human intervention, right? Hypothetically, imagine I'm a 12-year-old girl. I had a very bad day at my school. I come home and I send a text or a WhatsApp chat to my classmate that I'm so angry, I want to kill my teacher, I want to blow up my school. Now you just use these two words, kill my teacher, blow my school. And a 12-year-old girl is identified as a threat without looking into the context. That she's just a baby, she's just a kid, she doesn't mean it, she's just venting her emotions to a friend. And that is exactly why we need human intervention to understand this cognitive function which the humans possess. Is that so? How do you justify that you, as a machine, can never replace human judgment and human reasoning elements?
Your Lordship, I completely understand and agree with your concern. When
See,
I
if you
said
agree
that,
with all of us, then one of us is irrelevant.
no, Your Lordship, I agree with your concern partly, let's say, but then I would like to reason it out. When I said that it's just a machine, it's prior to when we enter into the contract with the government. The human intervention aspect comes down when we enter into a contract with the government, because then it's their duty to see all these concerns are also balanced with the.
Come to your prayer. The only thing you are left with is just pray.
In light of the present facts and circumstances of the case, it is most respectfully prayed that this honorable court may be pleased to issue an appropriate order or direction, quashing or setting aside the immune order passed by the DPDI. Secondly, hold that the applicant does not qualify.
What kind of writ it will? What is the nature of this writ? By washing. There are 5 types of writ.
Socially.
Go ahead.
Hold that the applicant does not qualify as data fiduciary under Section 2I of the DPDP Act and is merely a data processor. Thirdly, set aside the direction restraining the applicant from conducting AI research and training activities violated as allegedly violated in Article 91G. Hold that the data processing of CCTV footage and social media data by the applicant does not violate Sections 4 to 9 of the DPDP Act. Hold that the imputed penalty is disproportionate, excessive, arbitrary, and contrary to Section 33 of the Act. Lastly, grant any other relief as this Honorable High Court may deem to fit in the interest of justice, equity, and good conscience. Yes. Much obliged.
Yes, Mr. Counsel, what have you done? This entire thing, this Pandora box you have opened. You just gave blanket power to an artificial intelligence and private entity and shrug off your responsibility and come today standing against them.
Let me
Who? No, wait. First, hear me out what my queries are. My queries are, how can you delegate such a function to a private entity? That is one. Second, how can you stand against them when on your behalf they do the entire thing? Number 3, how do you justify Article 19(1)A, 19(1)G, Article 21 and Article 14? These are constitutional questions without going into the facts. Get on with it.
Sir, first of all, I have one preliminary objection to make regarding the maintainability of this petition. The petitioners have
We overruled it. We heard them at length. So the maintainability aspect we concerned.
but still there is an alternative remedy. If your lordship has heard it and says that it's maintainable.
No, it requires the jurisdiction's interference, so we will not delegate it to the appellate authority. We'll like to hear on that.
Right. The first issue that is before us, that whether Arohan Analytics Private Limited even qualifies as a data fiduciary or not. That is the moot question that is before us. Now, to start with at the outset, we have to firstly understand that what a data fiduciary is. Data fiduciary is contemplated under Section 2I of the DPDP Act. My lords, may I have the DPDP Act. DPDP Act, Section 2(1). Right. Yeah, please go. Data fiduciary means any person who alone or in conjunction with other person determines the purpose and means of processing of personal data. Now, what 2(1) contemplates that a person who alone or in conjunction with any other person determines the purpose and means by processing the data will qualify as a data fiduciary. Now, it is exactly our case that the Arohan Analytics Private Limited determine the purpose and means of the data jointly with the Ministry of Public Order. Now,
The nonsense is created by the Arohan Analytics Private Limited, and they surely determine that how the processing in the nonsense would be done, because it's a video streaming based AI platform which is installed in a CCTV camera, and from that what it does is that it identifies crowd movement patterns, it anticipates that, and in short the purpose behind this that it aids the security of the state. That is the purpose. But what under the guise of this they are doing, it is being clear by the para 4 of the MOOT proposition. My lord, we have para 4 of the MOOT proposition. Very good. But when the model was later pilot launched in 2025, it was accused of profiling people, recognizing faces, and marking behavioral patterns without permission. Some citizens complained that the system produced this scores marking some people as potential agitators based on clothing, body language, or crowd size, usually resulting in being questioned by the police or refused access to events. This is the purpose for which nonsense is being used. Now, what their case is that they fall under a legitimate use exception under 7C, and then they don't have to take consent, they don't have to send notices under section 4, 5, 6, and all of which is not violated. That is exactly their case.
But tell me something. If I'm walking on the street, I cross 10 CCTV cameras in my one movement. Do you expect them to take consent from me for each camera, for each image which has been captured? Do you think that is possible? If I'm going out in public, if I'm being citizen of the state, I have a duty that if my footage can be used for a general good, why not? Do you expect that they will seek consent from every individual at every level? Second, if they are using social media platform and YouTube, if I'm an adult, if I subscribe to Instagram, Facebook, WhatsApp, whatever, and I'm uploading some information about me, I'm tagging my friends, I'm tagging my location, I'm telling them my food habits and everything, I should take the responsibility that when I subscribe to it, when I accept it, this data can be used as a greater good. So tell me, give me the point where this consent, how do you take this consent?
Then we have to look at what is the mandate of the law under section 5.
Tell me what is the mandate of law?
Yes. What section 5 contemplates is when the data fiduciary has to take personal data of the data principals, then they have to mandatorily send a notice to the data principal. And what kind of notice? The notice should specify that this is the nature of the data I am taking, this is the purpose of the data which I am taking, and this is the extent of the use that I will use the data. Now, in our case, leave aside a notice specifying the purpose, extent, nature, what are the ingredients of section 5. No notice was given to the data principals and it directly falls under the violation of section 5. Now, section 5 also
So what have you been doing for so long? Because the non-state actor comes and gives a complaint. You are aware of this fact that this is going on in the country, and you have done nothing about it. And now you are arguing just that they have done wrong.
But it is their petition. I have to say, first of all, I had some preliminary objections to make. The petition is not maintainable. Since they have made us a party that we are before your lordships.
Who are you representing?
We are first of all representing not the Ministry of Public Order, we are representing the DRF and along with that the DPBI, which has passed the order.
It falls under whose jurisdiction? Your department, whoever you are representing, it falls under whose
We are a non-state actor.
You are a
Non-state actor, and the DPBI can be seen as something the tribunal, which is given in 227, the supervisory jurisdiction. The DPBI comes under the definition of a tribunal. So that is why they are filed under Article 226, Red Bill 227.
So are you careful enough when you make a statement that you do not come under the definition of state?
Obviously. There are multiple parties. The DRF does not come into the definition of the state. That is with the MOPO. In our humble submission, since MOPO is a joint data fiduciary, also it has been not contemplated by the DPBI in its order, but it's a joint data fiduciary. I may submit on this that if we look at the definition of the data fiduciary, What does it say? That the data fiduciary refers to a person who alone or in conjunction with. Now, the words which are used by the legislature, that in conjunction with, it determines a concept of a joint data fiduciary inside the Act. Now, joint data fiduciary as a definition obviously is not under the Act. It is through a interpretation that we interpret that the concept is recognized by the Act. Now, it is our case that the Ministry of Public Order, along with the Arogan Analytics, had gone into a public-private partnership saying that they are taking all of this data for the safety objectives of the state, for identifying crowd pattern movements, for identifying threats and to aid the safety objectives. But under the guise of this, the Nyan profiles people, identifies their behavioral patterns, and they are in grave violation of the section 4 to 9 of the Act. I will also
So what is wrong? If a one single bomb before explosion can be detected by the system, then I think more weightage should be given to that incident rather than just shouting aloud that my picture has been misused. Your data is to protect you. One bomb, if it can be diffused, you are just saving like thousands of lives. So what is wrong?
But then we have to see what the law says. We have to
Mr. Council, laws are static. The laws are not static. Okay? Before this case, we go 10 years back, nobody knew what AI is. We go 20, 30 years back, nobody knew what CCTV is. We go same time, nobody knew what YouTube or social media is. So law evolves with people. Okay? So cannot say that law will be amended. We will pass direction to union. You are saying you are not a state. We will treat them as a party and we will give directions. But tell me what is wrong if one bomb explosion can be prevented by using publicly available data? What is wrong?
Since this is the example which is being given by law, there is nothing wrong about it. But that is not the case which is before us. The case, may I supplement for 1 minute the brief factual matrix of this?
We are aware of the facts. Come to the legal issues.
Okay. Now, to argue on the very first issue regarding whether Arogan Analytics Private Limited even qualifies as a data fiduciary, the thrust of my submission is that if the Arogan Analytics Private Limited is evaded from their fiduciary status, it will defeat the purpose of the Act. Now, what is the purpose of the Act? We have to firstly examine that what is the purpose of the Act. The purpose of the Act is it was enacted by the Republic of India for the only purpose to protect the digital private data of the citizens, and it also was enacted for a particular reason for the AI innovation and innovation in data analytics. But the main purpose is that the protection of the digital private data of the citizens. Now, in this case, if the technical plea that has been accepted, that has been raised by my learned friend, accepted that they are the data processor. Now, what a data processor is? Data processor processes the data on behalf of the data fiduciary. So their argument is that we are the data processor. Please don't give all the safeguards which is being given under the Act to us because we are not the data fiduciary. We are the data processor. If such type of technical plea is accepted, then we have to also see that all of these enterprises, whether they are startups or any other enterprise, if they manage a large amount of public data, whether there are no reasonable safeguards. Reasonable safeguards are contemplated under the Act itself that you have to obtain under Section 4. What Section 4 says? That when you obtain data, you have to either take consent, and if you don't take a consent, it provides an exception that you should fall under the use of legitimate use. In their case, what they are trying to say that the safety objectives of the state is a legitimate use under Section 7C. I am not limit, is it not? No, but what under the guise of this they are doing? The safety objectives, if they say plainly, we can still understand that it falls under Section 7C exception. But under the guise of this, the MOOT proposition itself says that the Nyan sense profiles people. Now, if it profiles and identifies crowd patterns, now profiling is what? That marking their behavior and characteristic pattern and assuming that what this person will do. This is not what is contemplated by the Act. And if a fiduciary or an enterprise does this, then they have to follow the mandate of the protection which is being given under the Act. If they do not follow the mandate of the Act, then the penalty which is being imposed on them, that is correct, and the DPPI which has passed the order, that is also correct. It needs no interference, although my lords has contemplated that the petition is maintainable, although I had some other submissions, but since if it is maintainable, it need to be dismissed. Because the order which is being passed by the DPPI does not suffer from any inferences. The order is absolutely correct and the penalty which is being imposed is absolutely correct. Now, I will now directly come to the issue number 2. Issue number 1, I have concluded by submitting that they qualifies as a data fiduciary. Now, after this, connecting with the issue number 1, the issue number 2 is if they are the data fiduciary, they have to follow the mandate of section 4 to 9. I have to firstly establish that they are the data fiduciary. Then only the issue number 2 arguments can be moved forward. I have submitted that they jointly with the Ministry of Public Order determine the purpose and means of the Act, means of the data which is processed. Now, how do they do it? The purpose, it is admitted position, it comes from the Ministry of Public Order. It says that we are processing data for the safety objectives. The purpose is that. The means is the NANSENS, which is the AI engine, video streaming based AI engine. Now, if we read again the definition of the data fiduciary, I have already submitted who alone or in conjunction with any other person. Now, this is in conjunction. The Ministry of Public Order and the Arohan Analytics in conjunction processes the data and determine the purpose and means. So they are a joint data fiduciary is our humble submission for the issue number 1.
Let's have another hypothetical proposition here and justify it. As I asked to them, they are just a machine. They candidly admit that they are only a machine.
Facts are little different, but
here we go. They just collect the data. So they have collected the data of a particular city. There is a particular pattern of people. They have collected their data. They have collected their height, weight, clothing pattern, race, gender, and they have categorized potential threat level 3, threat level 2, threat level 1, green flag, blue flag. Accordingly, they have categorized certain individuals. Now, if some suspicious activity is being committed, does this machine issues a show cause notice, or does this machine, at the instance of machine, will file an FIR, or there will be a human intervention?
there has to be some human intervention.
There has to be a certain human intervention. I'm glad you admit that. So, if there is a human intervention, then how this data collection can be said to be violative? Because it is just collection of data. The ultimate decision which is being taken is taken by a human on the basis of rationality, on the basis of reason, on the basis of the cognitive abilities humans possess. That segregates us from machines and animals, right? So, if at the end of the day it's the human who's going to strike the pen, then how a system can be blamed that the system is in violation to Constitution? You understand what I'm saying? Address me.
First of all, then the issue is absolutely correct. There has to be a human intervention. Even if they collect data, there has to be someone to file an FIR. But in what manner they keep the data?
Forget the manner. Let's talk about the end. What's the end purpose? If the end purpose is justified, let's ignore the means. Or probably we will test the means on the basis of what the procedure has been enacted by Union of India. You candidly say you are not representing me. So we will analyze the procedure itself, because if a statute has provided a particular thing to do, it I'm sure has provided the manner it is to be done. And the procedure is not a constitutional validity challenge. So let us presume, and there is always presumption in favor of the law, that the procedure is correct.
First of all, what my lord has presumed that the end purpose would be positive. That it would be some kind of safety which would be taken off when there is a bomb threat, this AI will help. But what it actually does, my lord is absolutely correct on that point, that if it helps, then yes, it should be enacted. But kindly see para 5 now. I have read out that it profiles. Now just below that, para 5 of the MOOT proposition, what does it say? One of the RO1's whistleblower later disclosed that the firm also employed YouTube and public social media segments to boost facial recognition accuracy without warning the people involved or obtaining their consent. This is their hidden purpose.
So we have read this one. They only use this data for training purpose. They mask the faces. They don't retain it forever. They delete this data. It is only to generate and it's only to train the AI. What's wrong with it? Are you on Instagram? Are you on Facebook? Do you upload your selfie? Why do you bother if your data could be used to potentially disarm a bomb threat?
But sir, it does not potentially disarm the bomb threat. These are not the facts. If that is the facts, I am with my lord. So my lord is absolutely correct on that.
Petition is allowed.
Then we have to see the facts. We have to see the facts. We have to
Okay, address. I'm still not convinced, but please try.
Then I will come on to the issue number 2, which is the supplement of the issue number 1, when they are the data fiduciary. Now I will read out the section 4 to 9. I will first of all read section 4. When please. A person may process the personal data of a data principal only in accordance with the provisions of this Act and for a lawful purpose. A. For which the data principal has given her consent, that is not the case, or for some legitimate uses. This legitimate use is contemplated under section 7. Section 7 has many parts, that it provides certain legitimate uses. Their case allegedly falls under section 7C, which they are trying to put. We can also see what is 7C. I am reading the first line. A data fiduciary may process the personal data of a data principal for any of the following uses, namely, I will directly come on to the C, for the performance by the state or any of its instrumentality of any function under any law for the time being in force in India or in the interest of sovereignty and integrity of India or the security of the state. Now, the RO1 Analytics Private Limited is a private company. It does not fall under the definition of Article 12 other authorities. So they are not covered by this exception. They are covered by an exception if they argue that they jointly with the Ministry of Public Order determine the purpose and means. Then they can still fall. But we have to then actually see the facts of this case.
No, but the provisions say that the MOOT cooperated with RO1 under the public-private partnership to deploy AI sense in private. Then what's wrong with it?
What we did, yes, this is what my submission is, that they are the joint data fiduciary. I am also submitting.
So they are not directly on the definition of state in the article 12.
They do not fall.
They do not.
They do not fall. If MOPO falls, because it is obviously the state. And when you are the data fiduciary, then you have to follow the mandate which is of section 2, which is of issue 2, that
By of agreement, they don't become the instrumentality of the state.
Yes. It's an extended arm. State is not doing everything.
I understand the public function. That can be so. But that is so. But that has to be for a legitimate purpose.
This is legitimate purpose. Public security, public integrity of nation. But what do we get in that?
But in the guise of this, what they are doing,
What they are
that
doing?
has to be seen.
What they are doing? That's what I fail to understand. I'm asking you, but that's different ways.
I'm reading the para number 4 of the MOOT proposition. Yes. But when the model was later pilot launched in 2025, it was accused of profiling people, recognizing faces, and marking behavioral patterns without permission. Some citizens complained that the system produced risk scores, marking some people as potential agitators based on clothing, body language, or crowd size, usually resulting in misquestion by the police or refused access to it.
So my question again is how this becomes wrong if they are just profiling people. They have not convicted them. They are just profiled. They are just categorized. कि भैया इस तरह के लोग अगर देखें तो थोड़ा careful रहें. They are just helping. Don't you know in every police station there is a history sheeters? These history sheeters are identified on the basis of their past crimes they have committed, and whenever a crime is committed, they are first called in the police station. That we either investigation करनी है. So what is wrong if they are profiling certain individuals that could be a potential threat? They are not convicted. They are not put them under any trial. They are not being discriminated on the basis of their profiling. They are just mapped. So tell us how is it wrong?
Cannot be done under the mandate of the Act. The Act does not contemplate such situations that you can do it. You have
It says it can be done in national interest. You just read 7C.
national interest. This is not national interest.
We decide if it's national interest. You first have to justify why it is not national interest.
Had it been a national interest, it has to be something relating to the safety of the state. That is not made out in our legal submission. Although if your lordship comes to a conclusion, that is a different aspect. But in our legal submission, this does not fall under a legitimate use exception. Now, I will come on to the section 9 principle. What section 9 says? Section 9 says that the amount of data which is being taken from the data principle, that is to be of the limited amount what is required. Now it is the admitted case that the Ministry of Public Order under the Public-Private Partnership Agreement had supplied large amount of data to the Arohan Analytics Private Limited, and based on this, they regularly used to train their AI system. Now, this is a clear violation of section 9 data minimization principle. Now, I have covered section 4. 5, there is no notice. 4 is there is no consent. 6 also talks about consent, but it says that the consent should be free, specific, unambiguous. In our case, no consent is obtained, leave aside the other requirements of section 6. Section 7, I have said they do not fall. Now it all boils down to your lordship, what your lordship decide. Section 8, I have to cover, and I will conclude my arguments after that. Section 8 talks about that when any entity, which is the data fiduciary, processes the data, it has to apply reasonable safeguards. That there should be no unauthorized access, there should be no loss of data, there should be no loss of data privacy. Now, it is exactly our case that all of these things has happened, and the DPPI has correctly recorded. The DPPI in the para number 6, point number 8, point number 2 said that the Arohan Analytics Private Limited did not apply section 8, which is the data security, and section 9 data minimization measures, and other things which they have not done. So the order which is being passed by the Digital Data Protection Board is absolutely correct. It warrants no interference of your honorable court, and furthermore that they have an alternative efficacious remedy under section 29, and when there is an alternative efficacious remedy, what the Supreme Court says,
We are aware of it.
in 226 and 227 both, where
It's a larger than we can overrule something from.
if your lordship may para page number 30, I will take 1 minute while you log and then I will conclude. Page number 30 of the compendium. Judgment compendium. Article 226 is not meant to short circuit or circumvent statutory procedures. It is only when statutory remedies are entirely ill-suited to meet the demands of the extraordinary situations, as for instance where the very virus of the statute is in question, or where
Council Article 226 is discretionary. We are aware of it. We have already given our view. That alternate remedy is not efficacious here. So you can conclude that.
then I conclude my arguments, and I would like to call my co-counsel for addressing the lordship on the third, fourth, and fifth. I'm ready of it.
Council seeks commission.
Please. Ms. Council, tell me something. What is a legitimate aim in this entire case? Whether it is public security or data exploitation, which is a bigger picture. I repeat myself again. What is the bigger picture here? What is the legitimate aim of this entire case? Whether it is public safety and security or data exploitation.
In my opinion, Lordships, it's data exploitation. Sir,
Go
Lordships, merely because my data is publicly available, it doesn't mean that I can be profiled or be accessed on the way I am wearing a cloak or I'm representing myself. A police questioning me, making me a potential agitator. That is data exploitation, Lordships. It's not public security. In the name of public security or national security, you can't just make an individual labeled suspect. Public trust has to be obtained.
Okay. So data exploitation, which I just let's reframe this from exploitation to data analysis. Let's say this data analysis which is being done for the public safety, public security, for the data quality. Probably because of that, you have to see the end result which is trying to achieve.
Then Act provides additional safeguards, that is section 4 to 9. You can just really put out a notice or a notification that this is what will happen. This is what's going to happen. So we'll be careful.
Okay, go on. Go on. Start with this one.
Yeah. So the first issue which I'll be dealing with is whether the publicly available data is exempt from consent obligation under section 17(2)(a). So it is my respectful submission that 17(2)(a) of PPDP Act does not create an automatic or blanket exemption merely because data is publicly available. Lordships, if we read 17(2)(a), it is a conditional and operational. Its operation depends on fulfillment of legal and statutory obligations. The process, Lordships may have 17(2)(a). The processing may be carried out by an instrumentality of state, and such processing must be notified by central government for purposes such as public order or security. Now Lordships, in present case, the condition is not satisfied because our own analytics, it claims to be a private, while it claims to be a private entity, it is operating under the PPP model. There is no such notification issued by central government which places on record bringing aroma or nonsense within the scope of 17(2)(a). In absence of such notification, the petitioner cannot claim the benefit of exemption as matter of right by merely asserting functional proximity to the state. And where such exemption does not die, the consequence is straightforward. They have to comply with sections 4 to 9 as dealt with by my co-counsel. It is further submitted that the publicly availability of data does not extinguishes the consent requirement. That submission is legally untenable. Merely because my data is publicly available, it does not lose the character merely because it's shared on public platforms, as suggested by my lord that YouTube doesn't have that provision. If I'm uploading a content on YouTube, that is for public or limited social interaction.
Also, I don't agree with my views. So
Then also
let
Lordships.
me rephrase it then. If your data which is available publicly, you are consented, you are walking on the street, there is a CCTV footage, that data is being collected for greater good. Nobody is doing spying activity what you are doing within 4 walls of your house. Your personal space, your private space, your intimate space, that data, nobody is doing any surveillance. It is only the publicly available data. You're walking in a bank, the bank is seeing your pattern. You're walking in a railway station, the police is seeing if you leave behind a suspicious bag. You go to a mall, they want to see whether you're carrying a fire. That's for public good. And at every stage, if you suppose consent is required, then the system will collapse. So, nobody is doing any spying activity on your private life. It is only what you voluntarily post online. It is only what is voluntarily available by being a public part of public truth. Then how come it becomes bad and how come consent is required?
Lordships, if the fact suggests that the profiling and the spying, if it's not spying, then why I'm being labeled as a potential agitator or risk code, or I'm being questioned by police, or I'm being restricted to events, if it's not spying, then
Position doesn't say so.
Lordships, it does say so.
Yeah.
Just a second. The fourth paragraph, when the second last line, some citizens complain that the system produced risk scores, marking some people as potential agitators based on clothing, body language, or crowd size, usually resulting in being questioned by the police or refused access to events.
What if somebody is Christian? You just answer them and
No
go on.
lordships, but then my Article 21 is infringed.
Reasonable restriction.
But Anuradha Bhasin provides that prohibition, reasonable restrictions has to be on the four dimensions. It has
This
to
council, imagine a situation, I'm in Kashmir, I'm wearing a shawl, I'm carrying a stick. If the police is standing there, they look at me, it looks like I'm carrying a gun. They ask me, stop, take your robe off, your shawl off. I will show that this is purely a stick, not a gun. And they say, okay, go home. What is wrong? If I am being, there is a system which is identifying that please check it to prevent something which might be disastrous. If a system is identifying that for you without human intervention, what's wrong with it?
But then before that, why am I being labeled as potential agitator? That has to be a conclusion, lordships. It can't be a premise, first of all.
Okay, go on.
If let's suppose a beggar is walking on the street and he doesn't have proper clothing, it's torn from some part of his clothes. That doesn't mean that he has some agenda that he do that. If he's being profiled on the basis of his clothing, then his right of Article 21 collides with his right is infringed, lordships.
Continue.
I was on issue number 3, lordships, where the 17 to a consent obligation must be construed and interpreted narrowly in a manner that preserves the Act's protective purpose and prevents normalization of mass surveillance under the guise of using publicly available data. The second issue which I'll be dealing with is whether the 180 crores penalty imposed on Arohan was proportionate or compliant with the principles of fairness and accountability.
This issue number 5.
Yes.
Issue number 4.
I'll be dealing with issue number 5 first as my second issue. Lordships, the penalty imposed upon Arohan is lawful and proportionate and a necessary enforcement of accountability under the DPDP Act. Lordships, Arohan was not merely a technological assistant. Through Nayan Sense, it designed algorithmic architecture, deployed profiling mechanism, and determined how individuals were classified into risk categories. These functions bring Arohan directly under the definition of data fiduciary, that is, they determine the purpose and the means. Now, if it is a data fiduciary, it was duty bound to comply with the statutory duties under section 4 to 9, which includes lawful purpose, fairness, implementation of reasonable safeguards to prevent harm. But here, in this case, the board's finding is otherwise. It did not comply with the obligations, the 4 to 9 obligations. This feature attracts the penalty framework under section 33. Now, Section 33 provides for a maximum ceiling limit up to 250 crores. So the penalty imposed upon Arohan is well within the statutory ceiling, which is 180 crores. Lordship, this ceiling has been consciously prescribed by the Parliament for violations involving large-scale processing and inadequate safeguard. In present case, lordships, the breach arose from continuous and systematic profiling, which causes tangible harm to the individual. Therefore, lordships, the penalty neither exceeds statutory authority nor its arbitrary. Any nominal penalty would have undermined the seriousness of the breach and dilute the Act's enforcement mechanism.
So, how do you quantify somebody's privacy is very? What is very my privacy? How do you quantify it? Whether it's X amount or 10x amount.
That is the statutory limit provided by the
No, I'm saying if I have to compute, if I reach at a figure of 180, how do I quantify? Why 180? Why not 190? Why not 220?
Sir, the MOOT preposition.
So my question is again hearing out. How do you quantify the value of somebody's privacy?
Lordships, here in our case, the penalty was imposed because of the serious violations occurred on the part of ROP, which provides that up to 200 and 250 there are two ceilings on basis of which penalties can be imposed.
Go on.
And the MOOT preposition itself says that similar fines have been imposed on other companies as well.
Yeah, I agree on both series why they are different. One is 200 and one is 250. And what makes it was in the sitting or sitting on the second screen. It should be up to 250 or it should be up to 200.
So, firstly, the schedule, if we need breach and observance of additional obligations in relation to written under Section 9. Now, this is data minimization, Section 9. Breach and observing the obligation to give the board affected data principal notice of personal data breach under Section 6 of Section 8. There was no notice given, then also it lies under this threshold. And furthermore, Lordships, the amount of penalty is decided by the legislature. It is given by the Parliament. That's what the board is when we are complying with what the legislature has provided us. We are well within the statutory ceiling.
Because I have question remains the same. The ceiling is different. One is up to 250 and one is up to 200. So you are trying to put your case into up to 250 or up to 200. There has to be some segregation, right? Some differences there.
Lordships.
It says up to 50, right?
Right.
And it also says up to 200. So your case is, you are saying that it should be around 180. It should go beyond 200. Then it should fall in point zero.
It can be extended up to 250, and it is at the discretion that they want to.
Or maybe you are trying to say that the board had taken some balanced approach
In the Lordships.
because it is their first violation and it's just a warning for the ROI.
Board has taken a balanced approach, not just because they are the
Or submitting your written argument.
Lordships, and that it is their first which organs I will.
We have given this page. Page 35, the board has taken a balanced approach. The quantum of penalty satisfies the
Lordships, so there are 33 to give some mandates that nature and gravity of the breach, duration, type of personal data involved, the likelihood and extent of harm caused. Lordships, although they involved in high risk profiling and
No, answer in reference with the question of the bench. That why not impose 200 crore to 50 crore? You have already done that. But then they have taken a balanced approach.
Yes, Lordships. We have taken a balanced approach just so that
Okay, conclude the topic.
Okay, before we conclude the topic, I have a final question. I would put it as a negative form. Is pre-crime suspicion constitutionally valid or invalid? I'll repeat myself again. Is the pre-crime suspicion constitutionally valid or invalid? Crime has not been committed. I, as a state, only have a suspicion. Am I constitutionally violating any of it? Do we draw within the frame of constitution? Give me your answer.
Lordships, if it's in respect of violating my fundamental.
You remember the case of Keher Singh? Keher Singh was a history sheet. He was given a bail. What probably sentence was suspended. And police devised the mean to harass him is that at all hours in the night or early morning, they used to go to his house, take his attendance. Keher Singh ghar pe hai, and he has to come out and he has to say yes. And they used to do it randomly. Supreme Court said that yes, it is violation of his right to privacy. You cannot subject somebody to such a torture. But my question is the pre-crime suspicion constitutionally valid or invalid?
yeah, Lordships, it depends.
On
Depends on the rights.
of citizens' right. Okay. Coupled with directive principles as well of state. No. It is just we take it very lightly. We focus more on fundamental right rather than directive principles.
Rights, duties, and directive principles must go hand in hand.
Anyway, come to your point.
So, in light of facts and circumstances of present case, it is most respectfully prayed that this honorable court will be pleased to dismiss the present petition as being devoid of merit and uphold the legality and validity of the actions and directions issued by the respondents under the Act. Hold and declare that Aroma Analytics qualifies as a data fiduciary under Section 2I of the Act. Hold and declare that collection and processing of CCTV footage and social media data by Aroma Analytics for AI model training and profiling are in violation of Sections 4 to 9 of the Act. Hold and declare that publicly available personal data is not exempt from consent obligations under Section 17 to 8 of the Act when used for AI model training, profiling, or surveillance-oriented processing. Uphold the authority and findings of the Data Protection Board of India as lawful, reasonable, and in conformity with the provisions and objectives of the Digital Personal Data Protection Act. And pass any other order or discretion as this honorable court may be deemed fit and proper in the interest of justice, equity, and consent.
Petitioner. You are able to, right? Please approach.
Your Lordship's relationship, the respondent has fallen flat on multiple grounds. Firstly, the reiteration of the jurisdiction fact does not completely stand here, as the bench has already agreed that the writ jurisdiction here stands true because it's a question of law and a question of fundamental rights. Secondly, Your Lordship's relation pertaining to the prior notices, as the respondents have pointed out, but the respondents have also agreed that a lot of data is being processed. These two are contradictory statements, and it is impossible to send out so many notices. When individuals enter a public space, they should understand that they are under constant CCTV surveillance. Moreover, Your Lordships, the sending out of data as provided under Section 5 of the Act, there is an exemption which has wherein Section 5 must be read to Section 17C of the Act, which says that whenever any restriction exemptions are there in virtue of being an instrumentality of the state. Now we were guided by the PPP and the MOOT was directing us to conduct certain activities through the negligence. Next, Your Lordship, there is no commercial gain for the appellant to exploit the collected data. The purpose is to maintain public order, which can only be achieved by properly training the EAI, including the phrases used in general parlance. Even a kid using alarming words like kill and burn, upon training, the AI will know what is merely an exaggeration and what is an actual threat. Now, data scrapped from text and social media, for instance, it is not being surveyed. That is only for training purposes. And such phrases can be construed to be non-alarming if the AI is allowed to be trained in the first place. Next, Your Lordship, as the respondents have also agreed on the aspect of human intervention, the respondents are themselves the humans intervening and should be liable for any alleged activities that have been pointed out by the facts in the MOOT proposition. Next, Your Lordship, the respondents have mentioned that there was a whistleblower, but the Data Protection Board in their order has failed to assess the credibility of this whistleblower in the first place before imposing such a hefty penalty and the ban in question. Also, Your Lordships, I would also like to point out of page 16 of the appellant's memo under para 1.4, wherein we have cited an article by Amrita Ratnam and in footnote 4. It says verbatim that public-private partnerships are entered into amongst many reasons, but majorly so that the state in bonds of advanced resources can benefit from private entity. However, a private entity being perceived as a profit-focused machinery ends up bearing the brunt of faults of the government policy implementation and enforcement. Your Lordships, one pertinent argument and rebuttal is that the respondents have failed to address the feasibility test under 19.6 and why the test does not apply in the current facts and circumstances to demonstrate how Article 21 in this case is more important than 19.6. Lastly, Your Lordship and Your Ladyship, the respondents have failed to satisfy the mandatory test under Section 33, which is an and provision for the subsections as well as the provision in its entirety. The repetitive breach has not been answered by the respondents. The aspect of duration, nature, and gravity has not been justified properly as to why the 180 crore penalty should be should be granted in the first place. And since they are alleging a dignity-based harm, which is under Article 21, not a commercial privacy-based harm, which Kutuswamy has also not directly talked about, there is no proper loss or gain assessment done to give a penalty of 180 crores. The respondents have failed to establish any of the tests that the applicants have brought forth and satisfied as proportional and reasonable. Hence, I would like to rest my case. If the bench does not have any questions.
I have many, but I only ask one. Just answer and tell me, can a private algorithm or an AI do something which the Constitution forbids the state to do?
Your Lordships, no, but since the private organization.
You cannot have no and but in the same sentence.
Why not, Your Lordship?
We say that.
Your Lordship, if I could.
Okay, break your up.
Because the applicants were in an agreement, which was a public-private agreement with the government, then when there are certain things that the government can do, since Kutuswamy says that that kind of privacy can be let go of when national security concerns, public security, public order are heavier concerns to consider, then the then whatever the private organization is doing, directed by an instrumentality of the state, which is the over here, then it would absolutely stand valid to follow up. Much of that.
Whereas sir, it is allowed. Not allowed, but it's the discretion of the bench.
Census.
No problem.
No. Thank you so much.
Respected Dean Sir, all the learned faculty members, organizing committee of this MOOT competition, my learned fellow judges, Mr. Rajvendra Saraswat Sir and Mr. Garvendra Singh, myself from you all, and my dear legal professional young students. It is very nostalgic as I am at my alma mater. The MOOT court competition is held today. It is a very memorable event for all of you, I thought. Because MOOT court एक ऐसी प्रक्रिया है जिससे आपको क्लासरूम से लेकर डेली जो लीगल प्रैक्टिस में और प्रोसीडिंग्स में क्या चलता है उसका व्यू मिलता है, आप उस प्रैक्टिस को सीखते हैं। जिस तरह से दोनों टीम्स ने इतना अच्छे से अपनी एडवोकेसी स्किल्स को शो किया और they both are very well versed. I am really get impressed. I am from bench, तो मैं हमेशा मतलब हमें चुप ही रहना होता है बेंच की तरफ से। They both are counsels, learned counsels from Rajasthan High Court, so they are attacking. So don't get afraid. They both just trying to keep you on pressure that जो real life में होगा ना आप लोगों के साथ जब प्रैक्टिस करेंगे तब। But it was really good, memorable और मैं सबको बहुत थैंक यू कहना चाहती हूँ कि हमारे कॉलेज में इस तरह की इवेंट होना एक बहुत अच्छा संकेत है आने वाले फ्यूचर के लिए, आप सबके लिए कि आपको इतना अच्छा इवेंट देखने को मिला। और मुझे लगता है आप सबने बहुत सीखा भी होगा कि किस तरह से एक एडवोकेट को होना चाहिए। एडवोकेट भी वो होता है जो अपनी पार्टीज के लिए विजडम्स के चैनल से होते हुए लॉ को अप्लाई करते हुए एथिक्स के साथ अपनी पार्टी का केस रखता है उसके सामने, है ना। तो आप पर बहुत बड़ी जिम्मेदारी है, सोशल भी, लीगल भी। और एडवोकेट को ऑफिसर ऑफ कोर्ट कहा जाता है। तो मैं आपसे कहूंगी कि आप जब लॉ की डिग्री लें तो अपने आप को ऑफिसर ऑफ कोर्ट की तरह समझिए और उसी तरह से बिहेव भी करें। डबल ग्रेजुएशन की तरह होता है, ग्रेजुएशन होने के बाद ही ये कर सकते हो आप, ठीक है ना। तो एडवोकेट से ये अपेक्षा की जाती है कि मतलब लीगल प्रोफेशनल्स, जिसने लीगल प्रोफेशनल सबसे ये अपेक्षा की जाती है कि वो मोर रेस्पॉन्सिबल होंगे क्योंकि उन्हें कॉन्स्टिट्यूशन की जानकारी है। तो आप अपने देश के प्रति एक अच्छे नागरिक बने। इसी शुभकामनाओं के साथ मैं अपनी वाणी को विराम देती हूँ। जय हिंद, जय भारत। और आप अब दोनों जो हमारे लर्नेड जजेस हैं उनको सुनेंगे। दे आर वेरी इंटेलिजेंट एंड दे बहुत लीगल प्रोफेशनल, उनका अच्छा वास्ट एक्सपीरियंस भी है। थैंक यू सो मच।
How many of you hate me by now? No, it's very normal. I always get that feeling, but if you hate me, then I think I've done my job.
So, thank you so much, ma'am, and thank you everybody in university for inviting me. I'll just give a brief background. Practicing for last 20 years now, High Court of Udaipur. I was a very avid tutor when I was in my law school. I did my law from National University Udaipur, and I participated in all possible moots I could lay my hands upon that point of time. And I think mooting is one thing which ma'am rightly said is that it teaches you the practical aspect of what to do in the court and what not to do in the court. Because saying what is important and there is more important thing is what not to speak. Law is that's why called as a practice because you never perfect the art of advocacy. You keep practicing, you keep learning every day. It teaches you something different. And moot court is a platform where law students should participate, and I'm sure by observing you all that you people who are participating in the moot definitely are the wiser one who will come into the litigation side. I was in a law firm for 5 years, but then an epiphany happened and I came back to litigation, and I think I should have done that very early. I'll just give you, I'll not be very boring, not be very long. I know you have been here for a quite long time and you're going to go out and have a chai and coffee and all. But I'll be very briefly tell you what, in my personal experience, requires few qualities as an advocate. Because mooting is just to assess and to give you marks and a trophy. But once you step into the real life, your advocacy skills is going to decide somebody's future. Somebody coming out of jail depends upon you. Somebody's lost job depends upon you. Somebody's property earned over his life depends upon you. So there are few skills which an advocate has to have. Is that one, patience. Patience, patience and patience. There is no shortcut in this profession. It's a very hard-working profession. There is no shortcut. You have to give ears to it. And when I say you have to give ears to it, your ears do not be compared with somebody else's journey because you are walking your path. So don't think कि यार मेरे साथ वाले ने तो 3-4 साल में अच्छा ऑफिस एस्टैब्लिश कर लिया, मुझे तो मैटर ही नहीं मिल रहा है, मेरे को तो काम ही नहीं मिल रहा है. Don't let that feeling ever come in your mind. You are walking your journey. So patience is number one. Second, there is no substitute of hard work. This profession doesn't work on casual approach. You have to be very prepared with your facts, with the law, with the judgment, because you have to be very quick on your feet. If a judge asks you something and if you don't know, he might throw the file or probably he might give you a next date for 2 months or 3 months. And it's just your client is waiting again just because you are not prepared. So, hard work is very important. So, the first is patience, second is hard work, and third is perseverance, consistency. This profession makes you an advocate one day at a time. You are judged in a courtroom every day by your peers, by your senior lawyers, by judges, by courtroom staff. They watch you every day. How serious you are towards your profession. Whether you are inside the courtroom or always digging around in the chamber or in the canteen area. When you are inside the courtroom, are you in the courtroom or you are on your phone? They all observe it. And that's where the reputation gets built for a lawyer. This lawyer is how serious about this profession. So these three qualities, that's all. Nothing else is important and required in this profession. You have to be patient, you have to be hardworking, and you have to have consistency. If you can do that, trust me, sky's the limit. Yes, it is a very challenging profession, but trust me, I'm speaking as a first generation lawyer with no background of law when I ventured into litigation. I have no idea where will I get my work from. Maternal side, paternal side, no godfather, but here I am in front of you, very happy in whatever I'm doing. Now I'll just give you one instance on what I say about thinking on your feet, and it's an actual disposition which I read somewhere. Without name basis, I'll give you a very good example and you'll find it very interesting as well. There was a senior counsel in Bombay, and I'm sure a few of my friends have heard it. And I always say it whenever I meet law students. There was a senior counsel in Bombay. Very reputed, very senior. The judges also gave him a good amount of respect in terms of if he's arguing, the judges will not interrupt him because the judges knew that if they say something, there is some sense. But there was one bad or I would say misfortune that he was very forgetful. He used to forget things. He used to forget all small things about his daily life, not the matter. Matter is 100%, but he used to forget things. So he used to rely completely on his jury. He had a junior like me, somebody used to assist him every day, carrying his bag, carrying his file, when he's approaching the bench, opening the file, giving the notes, handing out the judgment, handing out the bare act. So he was completely relied upon by his junior. One day, the senior had to argue a larger bench disposition on a tax reference before a larger bench. Senior reached to the court in his chauffeur-driven car. Junior like me had to come all the way from train, somebody in Bombay, the trains, the rains, it stops you, and the junior was late. So by the time the junior reached to the court, he saw the senior is already on the dais and he already started arguing the case. Now the junior came running with his bag, file, brief, everything, and he sat next to the senior, opened the file, terrified, petrified, mortified. And then he suddenly hears the senior and he realizes that the senior is arguing against the client. The senior, standing on side of the appellant, is arguing as if he was arguing on side of the respondent. Now the junior को तो काटो तो घूमने वाली situation है because you are late, you did not tell him what to do. So he pulls the senior's down. And the senior just looks at him. Already the senior is angry that you are late. So he just brushes him aside. Then after 2 minutes, he again pushes his down. And the senior again brushes him aside. Then with the third attempt, he writes on a piece of paper that, sir, you are arguing from the other side. And he pulls the gown and he handed over the check to the senior. The senior looks at the check, reads it, giggles, says, and throws it away. And he argues for 10-15 minutes more. And you know the beauty of this profession? Then he says, my lords, whatever I've argued so far, that's the best argument my other side can ever come up with. Now let me argue my case. That is called as thinking quick on your feet. He realized he is going wrong. He realized that he has already damaged. But then he said, how to do the damage control? So you say that whatever I have done, I was doing favor to them. That's the best case they can ever come up with. So let me argue my case. That is called as thinking quick on your feet. And this is not taught in any textbook. Nobody can teach this. This is learned. This is learned over years and years of observing what your seniors are doing, what the court is asking, how you respond. So I'm very happy. I'm glad to be part of this amazing event today. So fortunate to meet all of you and humbled to be invited here. Wish you all a very, very good career. Thank you so much.
Practice. First of all, thank you so much to the university for inviting us in such a wonderful good competition. Both of the teams have worked really well. To add something to say something about this profession, I may share because when limited time has been given me to speak, to interact with people. See, of course, whatever he has said actually is the correct situation in this particular profession. You need to work hard. You need to see that you are sailing properly. You know, of course, various problems will be coming. For example, a number of people would be thinking after passing out from this law school that what career somebody would like to work in law firm, somebody would go for litigation, somebody would like to work for NGO. But as you can see, his career also, he was in a law firm and later on decided to shift to go into litigation. So, you know, you just need to say, you just need to work hard. And but the main point is that never think about the output. Just need to work hard. Output, you never know, this profession will give you something which you won't realize that, okay, I have worked on this some years back and today I am getting output. So generally what happens is that even the money or just because of money, just because of some other consideration, you may change your career. I may share a small life experience of mine when I was an associate to a senior, very good senior counsel of mine. So I was literally used to hesitate to interact with him. Only other than the formal briefing, you hardly used to speak. So I visited the city where in a wedding of my friend. So I just texted him, sir, can I meet you? At that particular time, he was the governor of the state. So he cordially invited me, you should come. I went there. Then he gave me around 1.5 hours just because I was an associate to him for around 6 months and I worked. And after 5 years, the recognition which I think I should have got at that particular time when I was assisting him. He very gently said that, Karmika, do you know that the case law which you research, which you have given to me by way of research, was quite helpful for me at that particular time, but I couldn't give you any shabashi at that particular time because if I would have given you, तो तुम साथ में आसमान में, but मैं आज को कह रहा हूँ कि यार you helped me in that particular matter and उससे मेरा बहुत कुछ आगे निकल गया. So this is the thing I'm trying to tell you. See, keep your eyes down and just focus on your work, just focus on your studies and keep doing it. Don't know, you never know when someone from somewhere will tell you, will come to you. It may be your client also, it may be your seniors also. So that's what I want to say, that keep focus on your work, on your studies, and then do whatever you want to do in your career. All the best to all of you, and thank you so much for such a wonderful event. I'm greatly mobilized for this particular event. Thanks so much.
Thank you so much. It is indeed a matter of great pride for me to stand here as faculty convener of Fiat Justitia 2026. I would humbly request our respected Dean Sir to kindly come on the dais to felicitate our judges for the grand finale.
ये हटवा दो क्या अब आप पीछे ले सकते हो पीछे देख लो
dignitaries to kindly come to the dais.
I request everyone to kindly maintain silence. The law is not a museum of antiquity. It is a living, pulsating thing which must move with the times and provide for the needs of the people. These powerful words of Justice M.C. Chawla resonate deeply today because over the past 2 days we have not merely discussed law, we have witnessed it in action.
Very good afternoon to our esteemed chief guest, Honorable former Justice Govind Mathur sir, our Dean Professor Dr. Anand Paliwal sir, Associate Dean Dr. Shilpa Sethman, Program in charge Dr. Priyadarshi Mathur sir, Faculty Convener Dr. Hansa Dheeraj Joshi ma'am, distinguished faculty and the very heartbeat of this event, our participants. I, Kashishashia, and alongside me is my co-anchor, Dhuri Nagori. It is a privilege to welcome you all to the Valedictory ceremony of Fiat Justitia 2026, the first national moot court competition, proudly hosted by University College of Law, Mlsu University, Udaipur.
As we gather to mark the culmination of this academic journey, let us begin by invoking the blessings of Almighty and seeking enlightenment. Now, I request all the dignitaries to kindly kindle the lamp. May this sacred flame guide us towards wisdom and harmony.
A university is not merely a center of education. It is a living tradition of value, scholarship, and collective aspiration. To honor the legacy of our institution and the spirit that unites us, I request everyone to kindly rise for the rendition of our Kulgi. Please note, no one will clap after Kulgi.
To formally open the proceeding and welcome our participants from across the nation, I request our Dean, Professor Dr. Anand Paliwal sir, to grace the podium.
Distinguished guests, learned legal luminaries, and aspiring advocates, we now move to a significant tradition of our institution, with formal felicitation of our venerable dignitaries in our culture. Welcoming a guest is akin to welcoming the divine. To lead this ceremony, may I most respectfully invite our Dean, Professor Dr. Anand Paliwal sir, to the dais to honor our guests.
Now, I request Professor Dr. Anand Paliwal sir to kindly grace the podium.
At the end of this Fiat Justitia, we are honored to have among us Fiat Justitia. The words they have chosen from a Latin maxim, let the justice be done. Let justice be done at any cost, whether the heaven is falling, but justice should be done. And in our scriptures also we read a word that is Nyaya Parmo Dharma. Means the righteous work. What is that? It is to do the justice. मतलब न्याय भी करना सबसे बड़ा धर्म है. And we are honored to have today as chief guest the person who is epitome for the same. Means to do the justice, whatever may be the consequences. That is, we have today retired Allahabad High Court Chief Justice and Justice of Jodhpur High Court, Sri Govindji Mathur sir. And our Registrar sir is also sitting here, our Associate Dean, faculty members, dear students, and all the students, participant students who have come from the different universities. I think the arrangements that has been made by the students, and I want to congratulate the efforts that has been placed by the organizing committee members. I don't think that there might have been any problem to the team who have come here to participate. Am I correct in my words what I am speaking? All the participant teams, I think they have taken care of your each and everything, and your stay and everything should have been comfortable. So it is the moment when one team is going to win this competition and is definitely going with the trophy. Other maybe runner up, but 47 teams
have participated, though 51 registered for the same. What in fact then we have learned, this MOOT code, yesterday during the inaugural ceremony also, you heard the words from the chairperson, Dr. Sri Mananji Vishra. And what is the importance of the MOOT code? He emphasized that MOOT code means the work, the hard work that you have devoted for preparing the memorials. MOOT code means the competition that the confidence that you have generated within these students. You may or may not win the trophy, but the hard work, the analytical skills, the argumentative skills that you have developed is really going to pay you in your career. This is something that is definitely going to benefit you. The resilience that only comes through all these MOOT codes only. Means how you react to the answer, your posture, your way to attend the judiciary, each and everything comes only through these competitions. And I think this is the first competition, national MOOT court competition that has been organized by this University College of Law. And all the efforts have been placed by the faculty, by the organizing committee to make this event a successful event. And today, in this valedictory session, we are honored to have Govinji Mathur sir, and we will be blessed by his words and the directions also for you, the students who are going to enter in this legal field. You will really be blessed today to have the words from Sri Govinji Mathur. I welcome you, sir, that will spare the time to address the students and also to visit our institutes. Once again, I welcome Sri Govinji Mathur sir and all the participant teams. I think you will go and you leave the Udaipur with a memorable memories only, with good memories only of this college. Once again, to all the participant teams who have come and participated in this event, to all the judiciary and all the persons, all the academicians, judicial officers who acted here as the judges for this competition, I thank my heartfelt thank for all that persons. But the most important is the role and the, that has been played by the organizing committee members that have made this event a very successful event. I thanks to all, and I once again congratulate to all the teams who have participated. Whatever may be the result, you go with the confidence and enter in your field full of confidence. All the good wishes to all the students and all the participants. Thank you.
Thank you, sir, for your inspiring words. A national moot court competition is more than a series of oral arguments. It is a culmination of months of meticulous planning, legal research, and administrative precision. To provide us an insightful overview of the journey of this competition, from the initial release of the moot proposition to the final rounds we have witnessed today, I have the honor of inviting Dr. Hansa Dheeraj Joshi ma'am to the podium.
Thank you so much. Regarding the event report, I stand here before you all to present it. The University College of Law, Fiat University, Udaipur, successfully organized Fiat Justitia 2026, its first national moot court competition from 21st February to 22nd February 2026. This landmark event brought together the finest legal minds from across the nation, establishing our college as a significant player in the moot court circuit. The competition witnessed participation from as many as 51 teams, representing premium law colleges from across the nation, competing on a cutting-edge proposition concerning artificial intelligence and Digital Personal Data Protection Act of 2023, a theme that positioned our competition at the interaction of technology and law. Fiat Justitia was more than a moot court competition, it was a statement of intent. The University College of Law, the oldest law college in Rajasthan, established in 1946, demonstrated that legacy and innovation can coexist. As far as the rounds are concerned, the event was conducted in preliminary rounds 1 and 2. For the purpose of conduct of our event, we have organized the rooms in considering the Rajasthan theme aspect. Marwar Matrix, Mewar Shield, Hawa Mahal Room, Blue Cloud City Room, Silicon Sand City Room, Ashoka Chamber, Lotus Room, and Amir Fortress. These were the courtrooms that we had for our rounds. As far as the rounds are concerned, I would like to clarify here. Out of the 50 teams that participated in the preliminary rounds, 8 teams qualified for the quarter-finals. The marking system was based on the highest score of a particular courtroom to ensure fairness, justice, and transparency. Out of the 8 teams that qualified for the quarter-finals, 4 teams were qualified for the semi-final rounds. And finally, as everyone has witnessed, we had the grand finale here itself. Regarding our judges, we were extremely honored to have as panel of judges as from the field of judiciary as RJS, GJS, AP, Senior Advocates of Rajasthan High Court, Special Public Prosecutor, Additional District and Session Judge, eminent academicians across the nation. So this was a collective effort, and as specified by Dean Sir itself, it is a collective effort of the organizing team that has made Fiat Justitia 2026 a grand success. Thank you so much.
Today, we are profoundly privileged to have in our midst a luminary whose career serves as a beacon of legal excellence and unwavering integrity. To hear from a personage of such stature is not merely a formality, but an invaluable masterclass for every aspiring advocate in this hall.
Honorable Justice Govind Mathur Sir, a jurist of exceptional caliber, his career has been defined by an unwavering commitment to the rule of law and the constitutional mandate. Sir has served as a former Chief Justice of Allahabad High Court and former Judge of Rajasthan High Court. Known for his incisive legal mind and landmark contributions to the bench, his presence today provides an invaluable benchmark for our aspiring advocates. May I now request Honorable Justice Govind Mathur Sir to share his words of wisdom with the Assembly.
Very good evening. Dean College of Law, Udaipur University, Associate Dean, other apparent members of the faculty, most precious students participating in Fiat Justitia, coming from different parts of the country, students of this university, ladies and gentlemen. Some people are born fortunate. I am one among those people. Because I am having very good friends, well-wishers, and even the students. Dr. Anand Paliwal and faculty of the College of Law, Udaipur, I found one of the best well-wishers for me, and they have given this opportunity to me to be heard in this auditorium before this very generous audience. This is really part of my fortune. Friends, Dr. Paliwal just mentioned Fiat Justitia, Nyaya Parmo Dharma. In my career of about 40 years in the judicial, I noticed that the person is standing at the lowest pedestal of the society, the people coming from the lowest echelons of the society, they desire only one thing. They are not concerned with several amenities. They are not concerned with a very good financial status. They want justice. I tell you two things. Before coming to that, you must have heard a famous incident, the importance of the justice. It is not only in India but in this entire globe. Every human being that desires justice. During the Second World War, in a cabinet meeting, the Prime Minister Winston Churchill of United Kingdom, he was with his colleagues, members of his cabinet. One minister just mentioned, Mr. Prime Minister, we are at the verge of collapse. Our system is going to collapse. We are going to lose our empire. Noticing his worry, the Prime Minister asked only one thing, Mr. Minister, whether our courts are not working. Most of our courts are working. Our judges are doing work. Our lawyers are adequately assisting the courts. Prime Minister immediately replied, Mr. Minister, then your apprehension is absolutely informed. If the last man of this country is having faith that he will get the justice, your system will not collapse. This country will not collapse. And that is the desire of every citizen of this country also. As a law student, we all are law students. Music and law. You are always required to remain a student. You can't say that I have learned everything. You are always in the process of learning. Well, our responsibility is to maintain this faith, faith in judicial, faith in a system, faith in members of the system, and for that, we are required to be exceptional. It is for us, judges, lawyers, law students, working in corporate groups, that yes, we have learned this law. These are our constitutional values. We can't compromise with these values. That is the requirement. When you are here in Fiat Justitia, the clear message given by eminent faculty, eminent professor is that yes, we are going in society. You will be in the ocean just to protect the justice. You are to protect the constitutional values. You are to maintain faith of the person standing at lowest pedestal in our judicial system. So far as I am concerned, I am here to learn from you. In next few weeks, I am going to complete 67 years of my age. In my college days, there was only classroom teaching. I was not at all aware with this mooting concept that came in 1986-87, I think so. At the first instance, I witnessed MOOT court in 1987 at Udaipur, where 13 Supreme Court judges participated. That was a MOOT court conducted by the Bar Council of India with Udaipur University of. Prior to that, and at that time I was a lawyer of 4 years. So far as I am concerned, I read 18 classical subjects of law, 6 subjects every year, nothing else. And that too, law was not a choice. You must be knowing that up to 1968, law was in evening classes, 2 years course. Subsequent to that, 3-year course. In my era also, it was evening classes, no regular classes. But you are the fortunate people who are participating in clinical style also. You are not confining yourself to the classroom. You are the persons who have learned a lot from society, from after a deep observation by eminent jurists. Our parliamentarians, judges, lawyers, teachers, they have given a lot to this country. And you are the largest consumers. When I am saying consumers, that doesn't mean that, as a matter of fact, every citizen of this country is consumer of justice. But you are the people who will assist in delivery of justice. You are the part of justice delivery system. You are the most precious part of justice delivery system because you are teaching the things which are absolutely new. Whatever I learned that was in existence from last 40 or 50 years. But you are learning the subjects which came into existence few years back. In my era, a worldwide slogan was "Workers of World Unite." In your era, technocrats of world unite. You have a lot of technology, and you are the craftsman who is turning this technology in law. You are not simple, a professional like me. You will be a professional with deep commitment, with deep learning. I am completing 67 years, just I said. I further want to live at least for 21 years. Because I want to see 100 years of my independence. And why I want to see? Because of you. You are the people who will give a new shape to this country. Yes, we have contributed in making foundation, but foundation all right. a beautiful look to the nation is required to be given by you. नीम के पत्थर और तंबूरे. These are two words. There may be foundation stones, but the beauty, amenities, facilities, comfort that comes from the actual building. And you are the people who will construct this building, and I want to witness this. I want to witness a new country. After 100 years, I want to see, yes, I have witnessed 75 years, but the coming 25 years, that will change the total scenario. Up to 99 degrees, water remains hot, but at 100 degrees, it boils. You are the people who will give that temperature to our society, to this nation, to bring the country on boiling stage. And that's why I am here. That's why I want to learn. And what to learn? When I saw your brochure, this was mind-boggling for me. मैं देखता आया कि रामू के यहाँ से इतने रुपए उठा करके ले गया, चोरी हुई, ये हुआ, या उसकी जमीन उसके खाते में चले गई, या ये नौकरी से उतर के आ गए, मेरे मुकदमों की दौड़ यहाँ तक. और आज absolutely a different concept. You are talking about world issues. You are talking about cyber crime. You are talking about AI. I was just telling you, Dr. Paliwal, this Digital Personal Data Protection Act 2023, this is absolutely new to me. In fact, in my career of 37 years in judiciary, 17 years as a judge and 20 years as a lawyer, I had no occasion to deal with such matters. And you are arguing in your college days. So you are the people who are having great opportunity to serve the country and also to save the country. Friends, the technology may further ahead. Today I am saying that I am not of much relevance, may not be totally irrelevant. And I am telling that you are absolutely relevant to me. But after 50 years, when one from among you will be here, he will say that today I am not feeling myself much relevant. The person sitting before you, they will be relevant at that time. This is the movement of society. This is the progress of technology. This is the kinetics of law. But certain things are there. Those were existing in 1950 also. Today also will remain as it is in coming years also. Those are our constitutional values. Our constitutional values those will remain in currency. Those will remain relevant in every coming time. So when you are discussing this law, you see how the law and values also moves time to time. Nobody thought that Article 21 that talks about the liberty of life and and personal liberty, fundamental right of life and fundamental liberty. In Puttasamy's case, they included privacy. Privacy is a part of Article 21 and not simple privacy that further bifurcated it. Bodily privacy, information privacy, and autonomy to have own decision. Decisional autonomy. I also had an opportunity to pass a judgment relying upon case Puttaswamy. That was the case commonly known as name and shame. That was regarding some posters on the streets of Lucknow city. So we are required to see that no law and no action that may adversely affect our constitutional values, including delivery of justice to every person. Before coming to this auditorium, I was just going through some e-journals. A bail application has been rejected by a judicial magistrate at time. I am not criticizing, but so far I am just touching the legal issue. The order has been quoted. That is the dismissal of the bail application preferred by the accused persons arrested while protesting and demonstrating before this AI summit. Yes, it is discretion of the court, and by relying upon law, application can be rejected, not necessarily to grant bail. But when you are dismissing or accepting a bail, when you are passing any judicial order, when you are writing anything, as a student also, what is mentioned in the order is that it is a question of our diplomatic image and image of this prestigious program, and therefore the issue regarding individual liberty that can be ignored. I think in any event, your fundamental right and the constitution can't be put on the back seat. Reject the bail application. This I just an hour earlier I read this one. It was hammering in my mind that how this can be mentioned. That let the constitution be ignored. Constitutional rights be ignored. That can't be done. Friends, you must, while supporting or opposing this proposition given to you, you must have discussed a lot of things. Your brilliance, your craftsmanship, your acumen that have sharpened your views. Someone from among you will get the award. Someone has only participated. But that doesn't mean that the person who is winning is having a better knowledge of. Everybody is on same pedestal. Yes, today is his day. He is winning the award. Tomorrow you will carry the trophy. But the fundamental thing is that you have participated, you have addressed, and while addressing, you have maintained values of our constitution, values of the system of education, values of the your university, and values of the host. This is much more important. While going through the provisions, the Act of 23 and rules framed there under 25. There can be two different ways for examining, for looking into the rules. One is, this is the law. You all are at the threshold of your career. So one way is that this is the law. Other thing is, yes, this is the law, but the law should be like this. A thing in a lawyer's style is a different. A clerical style is, a ministerial style is, a bureaucratic style is, yes, this is the law. And this is not wrong. Because a bureaucrat is required to work as per law. But a lawyer, a legislator, he is required to think, all right, this is the law, but law should be like this. This law is correct to this extent. It should be worded to that extent. Always keep in mind that this analytical process must go in your mind. You must think that ultimately whether this law serves citizens of this country or not. This is necessary and this is thinking like a lawyer. Otherwise, a static mind that will give you only a tendency of acceptance, only feeling to survive. You need feeling to survive as well as to struggle. So you have to make your thinking process in that fashion. You must have heard that this Act of 2023, that is also subject matter of challenge. Only the 16th of February, a bench of 3 judges, including the Chief Justice of India, invited response from the central government. And while doing so, they have mentioned that this is one of a fundamental issue relating to privacy of Indian citizens. Therefore, we deem it appropriate to examine all the issues raised in this petition by a larger bench. Matter has been referred to a larger bench. And larger bench, why that is required? That yes, we are required to think that how this law should be. I hope in this 2 days meeting, in this competition, you must have applied your mind. Let apply your mind little more to give much more to our society. Our society is looking towards you with greater hopes for their better tomorrow. Thank you.
Thank you so much, sir, for your words of wisdom. And now we finally arrive at the moment that has kept every heart in this hall racing. The scores have been meticulously tabulated, memorials carefully evaluated, and the final rebuttals weighed with precision.
to honor the excellence we have witnessed and to announce the champions of this historic first edition, we are privileged to invite Dr. Hansa Dheeraj Joshi ma'am to the podium.
Now, the most awaited moment has arrived. Declaration of results. The team that is adjudged as winners at the grand finale of Fiat Justitia 2026 is team code TCFJ 17. Respected Dean Sir and respected Program in charge Sir, Associate Dean Dr. Shilpa Singh ma'am, Dr. Rajeshri Chaudhary ma'am, and other faculty members who kindly join for the stage of this event.
ये जी बचाई तो बीच में मत
They are receiving a cash prize of 11,000 rupees as winners. A huge round of applause for the winners. The runner-ups, team code FJ37, Office General Government University, Speaker. Speaker 1, Vaishnavi Agarwal, Speaker 2, Varsha Parwar, Researcher Rashi Chavan. They were adjudged as the runner-up. They have just left by few marks, I must say. Huge round of applause for runner-up of the Justitia Grand Finale. They have received a cash prize of 9,000 rupees.
थोड़ा सा बचाई
Best Student Advocate. Team code. Before I proceed further, we have chosen the best student advocate from the preliminary rounds. Highest scorer of both the rounds. It is team code FJ 1717 Anirudh Soni from MLS University, Department of Law. Huge round of applause for best student advocate Anirudh Soni. Best Memorial Award goes to team code FJ19, Government New Law College, Indore. Speaker 1, Jia Rao, Speaker 2, D. Ratwanshi, and Researcher Aniket Chaudhary. Huge round of applause for best memorial winners. I now request the semi-finalists, team code 14, Rice University, Bangalore, and again Government New Law College Indore to kindly collect the certificate for as semi-finalist. Quarter finalist, Aligarh Muslim University, team code 2, Amity University Punjab Mohali, team code 5. Please give a huge round of applause for the semi-finalists and the quarter finalists as well. B.R. Ambedkar National Law University Sonipat, team code 16, and St. Vincent Law School Pune, team code 45. I request the quarter finalists to kindly come near the dais. I now request Ms. Nehal Jain to kindly announce the name of the participating institutes. Team code 1, Ashwina College of Law. Team code 3, Aligarh Muslim University. Team code 6, Apex School of Law. Team code 7, Asian Law College. Team code 8, Baba Saheb Bhimrao Ambedkar University, Lucknow. Team code 9, Banasthali Vidyapeeth. Team code 10, Bhopal Local University Faculty of Law. Team code 11, Campus Law Center, University of Delhi. Team code 12, Christ, Delhi NCR. Team code 13, Christ, Pune. Team code 15, Maharashtra National Law University, Jabalpur. Team code 18, Government Law College, Bhilwara. Team code 20, Gujarat National Law University, Gandhinagar.
Team Code 21, Guru Nanak Dev University, Amritsar. Team Code 23, ICFI, Law School. Team Code 24, IFCAI University, Jaipur. Team Code 25, Integrated Law Course, Faculty of Law, Delhi University. Team Code 26, JCRC University. Team Code 29, Campus College of Law.
Thank you.
Team Code 31, KLE Law College. Team Code 33, Kurukshetra University. Team Code 34, Lord's Universal College of Law. Team Code 35, Maharaja Sayaji Rao University of Baroda. Team Code 36, National University of Study and Research in Law, Ranchi. Team Code 38, Punjab University, Regional Center, Ludhiana. Team Code 39, Prestige Institute of Management and Research, Department of Law, Indore. Team Code 40, Samarman School of Law. Team
Thank you.
Code 41, School of Law, France.
Team Code 42, Shantaram, College of Law, Chandrapur, Maharashtra. Team Code 43, Shri Navalmal Firodia Law College. Team Code 46, Thakur Ramnayan College of Law. Team Code 47, United Girls School of Law, Karnataka University. Team Code 48, University 5-year Law College. Team Code 49, University of Mumbai Law Academy. Team Code 50, University School of Law and Legal Studies.
There is one, so there is one team, so there is one team, so there is one team coming in. University of Mumbai Law Academy.
Let us have one more resounding round of applause for all our winners. Education has set a new benchmark for Fiat Justitia 2026.
However, we would also like to speak directly to those who may not be holding a trophy today. In this legal profession, a loss is rarely the end of the story. It is often the beginning of a stronger argument.
As you move from these simulated courtrooms into the vast and complex landscape of the real legal world, remember that your research, your integrity, and your commitment to justice will always remain your greatest assets. I urge you to become long-term contributors to the legal growth story of our nation. Voices for the voiceless and minds that advance the frontiers of jurisprudence.
Now I invite respected Hansa Neeraj Joshi ma'am to come on stage and please felicitate our organizing committee.
Just sorry to rectify you. OC will be felicitated by respected Honorable Chief Guest Sir and respected Dean Sir, Program in Charge Sir. As far as this event is concerned, as I specified previously, the backbone of this event is my OC. So huge round of applause for my OC. Huge one. They deserve this. We had a core team of 6 members who have been working continuously, consistently from past 3 months to make this event a huge success. They are my backbone, they are my heart and soul for organization of this event. I now call upon with great pride My core committee, Ms. Himani Rathod, creative head, she has supervised social decorum and led the decoration to maintain both discipline and aesthetic excellence. Huge round of applause for Rosie. Mr. Mudit Paliwal, cultural head, who has handled groundwork, stage supervision, and led the escort team with efficiency and coordination. Huge round of applause for Mr. Mudit Paliwal. Navneet Sharma, who has supervised social media management, logistics, and technical department, ensuring seamless back-end operations. Huge applause for the OC. तालियां पूरी नहीं चाहिए OC के लिए. Siddhi Pawar, who oversaw communications, coordinated hospitality for esteemed judges, and served as the event coordinator. Ms. Tanya Deval, who managed the designing. Ms. Tanya Deval, who managed the designing and drafting of the banners, certificates, handled participant communications, registration, and had played a very important role in the declaration of the results. Huge applause. And yes, it is incomplete without Mr. Nikhil Megwal, who managed accommodation, participant hospitality, and PR, ensuring a well-coordinated experience for all. And now, yes, this is just the beginning of my committee. My committee has to come in more. I now request the registration team to come forward. Huge round of applause. I think I have to give that reminder again. Accommodation team. All those who are in the registration team, I request all my OC members to please gather here at my right, extreme right. OC, please first. Registration committee. Registration committee, please. Followed by accommodation. Accommodation team, hospitality. I request the OC to kindly make the process smooth. Certificate committee, yes, again, it is incomplete without you, Pratyaman. Huge round of applause for our certificate team. Groundwork team, those who have, have spent sleepless nights, I must say. Right from, waiting for the screen to come up 3 a.m. in the morning. And till the time of, just keeping awake the whole night to ensure that the event is in place. Huge applause for my groundwork team. Next, my timekeepers. What would we do without, timekeeping? Accurate time management. All credit goes to my timekeepers and my CCs. Huge round of applause for my timekeepers. Huge round of applause. I think you're all damn tired. But so is my committee, but they deserve this. Anchors of Fiat Justitia, inauguration and valedictory. Yes, again I need to give that reminder. Huge round of applause for all the members of the OC. Anchoring team, anchors of the inauguration ceremony and that of the valedictory ceremony. You have ensured that the things have flown as we have decided as per the schedule, and you have played a very significant role in delivery of the content and the flow of the event. Huge round of applause for the anchors. Here they go. Next, of course, more I talk about them, the less it is. They deserve a special mention, I must say. My creative team, they deserve a huge applause for the record that they have done throughout the premises of the college that we see. Right from designing Marwar, Matrix, Mewar Shield. If you realize, we have our city of Rajasthan representing our Rajasthan. As our courtrooms, we stand here to glorify the history that we are known for. Our Rajasthan, Maro Rajasthan. That is what my team has ensured. We represent Rajasthan and our courtrooms were Marwar, Matrix, Mewar Shield, Silicon Sand City, and you will see the decor. How beautiful, how fine it is, and everything is handmade. Everything is handmade in today's modern technology times, where we have just taken our printouts and done the things. Huge applause for my creative team here. Of course, it is incomplete without Himani Rathore. Himani Rathore. Thank you. Yes, the beautification further went on. Rangoli team. A huge round of applause for the traditional and the beautiful Rangoli that we have put at the entrance of our block B, and of course near our ground, wherein we have portrayed technology and tradition together. Huge round of applause for the team that has given life to our tradition. Rangoli team. They have made it very clear right from designing till the time of choosing of the colors. They have ensured every minutest thing. So huge round of applause for the team that has made the beautiful Rangoli for our event. The cultural performance was magnificent. I request my cultural team, my dedicated professional team of dancers to kindly come up on the stage. Those who have reflected Rajasthan culture in a very beautiful manner. I request the cultural team to kindly come on the stage. You have made the impossible possible, right from carrying chari with fire on your head. I believe Khushi is also here. Khushi Rameja. She is the master of sword fighting. Loud applause for her. Flying forward sword fighting. What a performance it was by her. It deserves a huge applause. Khushi Rameja. Huge round of applause, please. Welcome committee. Welcome committee. Those who ensure, as we know that Atiti Devo Bhava, we are very much known for hospitality, our welcoming. They have ensured that they have been there from the morning till the night to welcome the dignitaries, the guests and the judges, and of course the participants for the entire session. This is welcome team. Thank you so much for your contribution. And of course, last but not the least, What would we do without the technical team? So here comes to my technical team. Arvind, the master behind it. Technical aspect is not easy. Let me tell you. He has done it. Huge round of applause for the technical team because without technology we cannot function. Thank you so much, respected Chief Guest Sir and respected Dean Sir. Now I request Dr. Priyadarshi Nanda Sir to kindly extend vote of thanks.
A very good evening to everyone present here. I, Dr. P.D. Nanda, Program in Charge, BLC, UCL, MLSU, welcomes you all on this proud and memorable occasion of valedictory ceremony of the Fiat Justitia first National MOOT Court competition organized by University College of Law, Mohanlas Arya University. It is my privilege to extend the heartfelt vote of thanks on behalf of organizing committee as well as UCL. First and foremost, we express our sincere gratitude to our Honorable Chief Guest, Shri Govindji Mathur Sir, Honorable former Chief Justice, Allahabad High Court, for sparing valuable time to grace this ceremony and for inspiring us with insightful words of encouragement. Your presence has truly elevated the significance of this event, sir. We are also grateful to our institute's leadership, Professor Anand Paliwal Sir, Team UCL for his constant guidance, encouragement and support in organizing such enriching academic activities that nurture professional skills and legal excellence among the students. Thank you so much for providing us such a large platform and believing in us. We extend our deepest appreciation to the learned judges who judged the various rounds during the event with dedicated, valuable time, expertise, and patience in evaluating the rounds with fairness and professionalism. Your constructive observation and thoughtful questions have greatly enriched the learning experience of all participants. Here I would like to share that our judges panel was the blending of judicial officers, senior advocates and academicians. Again, thanks a lot to them. I would also like to express our heartfelt thanks to the participating teams from various prestigious law institutions across the country. Your dedication, rigorous preparation and competitive spirit have made this competition intellectually vibrant and successful. Regardless of the results, each one of you has demonstrated exceptional advocacy skills and academic excellence. Many congratulations to the winner and runner-up teams, and best wishes for the future ahead. My sincere thanks to Dr. Shilpa Seth Ma'am, Associate Dean, for overall supervision during the event, and Dr. Rashi Chaudhary Ma'am for monitoring stage setup and constantly motivating us throughout the event. My colleague, Dr. Bhavik Paneni Sir, for giving best plan for sitting and attendance of the students. My dear Dr. Kalpesh Nikaut Sir, for always being with me in the entire event and for managing and monitoring transport facility throughout the event. My colleague Dr. Sneha Singh Ma'am and Dr. Pankaj Meena Sir for managing and taking care of hospitality and accommodation of all the teams during the event. Our esteemed faculty members Dr. Deepthi Sharma Ma'am, Dr. Neha Damani Ma'am, Dr. Megha Bhatnagar Ma'am Ji for creating the themes and scripts of the event and preparing the students for the event. I am also thankful to Dr. P.C. Garg Sir, Registrar Sir, and Dr. Mukesh Barber, Controller of Examination of MLSU, for helping always whenever it was needed. A big thanks to the University Estate Office, especially Ravindraji, for keeping the good pace of maintenance and repair works, including beautification of Law College. Now my big thanks to the entire staff of Law College, Shri Nareshji, Chandanji and Mahavarji for arranging funds and settling of accounts. Yogeshji, Gautamji, Nareshji, Girwal, Mukulji for quick technical and other ministerial works. Kaluji, Himmatji, Kedarji, both Devilaji, Panditji, Rajeshji, Santoshji, library staff, Prabha Madam and Shikaji, both Rohitji, for continuous hard work from morning to evening from past few days, whenever it was needed. I am really thankful to all and forgive me, law college staff, that I have behaved rudely during the event with anyone. Coming up now, I want to thank two most important ones who have put up their continuous hard work with their heart and soul, shown a lot of patience from past 3 months to give the shape and structure to the event to rise up the same at such a high level what we are seeing today. First one is the organizing committee of Fiat Justitia 2026. I want to thank you team from bottom of my heart. Attending an event and organizing an event is a difference, and that you have shown to everybody by putting so much physical and mental exercises. I am really lucky to have you with my team. Last not the least, I want to thank Dr. Hansa Bhargav, who was constant companion for me since the initiative. Making the MOOT proposition, we have worked day and night along with teams here to Justitia to line up the events in its proper shape. My sincere thanks to the faculty members, coordinators, volunteers, support staff whose tireless efforts, careful planning and teamwork ensured the smooth conduct of every stage of this competition. Without your commitment, this event would not have been made possible. I want to thank and acknowledge our knowledge and media partner SSC Time also. Finally, I thank everyone present here, guests, participants and audience, students for contributing to the success of this national moot court competition and making it a truly memorable experience. With this word, I once again express my sincere gratitude to all who directly or indirectly contributed to the successful completion of this event. Thank you all.
Now I request Professor Dr. Anand Paliwal sir and PD sir to please felicitate Dr. Hansa Joshi Khan.
Together for a group photo. All my OC, please assemble in the dais class. This is incomplete without you. It is all yours. It is not mine. It is all yours. OC, please make it fast. नीचे खड़ा भी जाइए। लोअर नीचे। That side also go fast.
थोड़ा पास आओ
अरे तो आप करें किसी को
हमें हमें चलो
In honor of our motherland and to invoke the spirit of unity and devotion, I request the entire assembly to please rise for rendition for our national song, Vande Mataram.
Vande
I request all of you to remain standing for the national anthem.
पंजाब सिंध गुजरात